Greetings. Welcome to our video on fundamentals of South African labor law. Now, this is a series of videos which look at different aspects of labor law. This is the first in that series, but there are many others that you must look out for, which deal with various aspects of South African labor law, as you will discover. Right, so we are looking at fundamentals of South African labor law, and my name is Dr. Philani and Ndlovu. Thank you very much for being part of this presentation. May I remind you to subscribe to the channel by, clicking that subscription button, clicking the notification bell as well, so that you can be notified when new videos are posted. Remember to like the videos and to share with your friends to support the growth of the channel, so as it were. So we are looking at fundamentals of South African labor law, and we've got quite a number of questions that we would like to pose to you as we begin. Are you a worker who provides labor services to another person in exchange for remuneration? Or are you a business person who uses the labor of another person and you pay them for the labor that they provide, maybe at the end of the week or at the end of a month or whatever period? Are you economically dependent on a parent, a spouse, a family member who is employed by another person? Would your life be thrown, your life, would it be thrown into disarray by the dismissal of the person that you're dependent on, if they are dismissed from the place where they work? So those are the questions that we want to answer, that we want to have at the back of our minds as we go ahead with this discussion. You could also be a student of law at a university or a a tertiary institution, and you are studying labor law because you want to get an insight into it. Or you could also be a member of a trade union, or a leader in a trade union movement, and you are hoping that you will gain insights that should sharpen your skills, as it were, as you participate in the union activities. Take note of that. Take a back seat and enjoy, the exposition that we are going to make on this video. So we've got quite a number of objectives here that we would like to have at the back of our mind, and we would like to meet those objectives by the end of the video series. It says by the end of this lecture series, you should be able to define an employment contract and distinguish it from contracts which bear resemblances to it. And you should sketch out the labor law relationships between an employee and an employer and other stakeholders within the legal framework of labor law. And you should be able to also outline the role of the main role players who fall within the regulatory ambit of labor law, and identify and elaborate on the various sources of South African labor law. You should also trace the historical developments of South Africa's labor law, and then discuss the priorities of South African labor law in the post-apartheid era against the backdrop of the need to protect the employees from unfair dismissal, unfair labor practices, collective bargaining, and fair dispute resolution mechanisms. And you should also be able to contextualize the employer's rights to corresponding forms of industrial action, such as lockouts, such as, and the circumstances under which employers may fairly dismiss employees. So these are the issues that you should have at the back of your mind as you think about all this. So our question then is, what is labor law and why is it so necessary for us to study labor law? I hazard a definition here where I say labor law is the branch of the law that deals with the relationships, rights, duties, and responsibilities of workers and employers trade unions and employers organizations, as well as the state, in respect of the provision and use of labor, defining how the parties to a labor contract ought to conduct themselves within the context of the relationship. So as you can see there, we have relationships, we have rights, we have duties, we have responsibilities, and we have identified quite a number of stakeholders. So at the onset there, you find we have got the worker and the employer as the primary role players, but there are many other role players like the trade unions, government itself, and employers organizations, because all those are interested parties. Of course, we know that we have NEDLAC, which is the National Economic Development Council, a labor council. So we find that labor law intersects with various legal disciplines such as the law of contract, the law of delict, criminal law, administrative law, company law, constitutional law, as well as international law. So these forms of interaction, this intersection, will actually be highlighted in the course of the series. Certainly not in this video, but in many other videos that are also part of this series. So in order to get a full grasp of labor law, you must ensure that you have access to all the videos in the series. And we are saying that labor law occupies a central role of labor in the national economy. In fact, it occupies a very central role in the national economy. It is politically significant. And we find that because the means of production such as land, mines, factories are owned by a few individuals, the rest of the population can only sell its labor in return for remuneration as the only guarantee for individual economic survival. So it's not as if the people that are employees have a choice. They find themselves in that precarious scenario where the only means of survival is to sell their own labor in exchange for remuneration or a salary. So it has actually been observed that work is fundamental to definitions of self and provides status, esteem, and meaning to the person sufficiently fortunate to be engaged in it. And the loss of employment, especially in economies with high levels of unemployment, South Africa in this case, will most often have devastating personal consequences for a worker and the worker's family, because work is a means to sustain material needs and escape poverty or lack, and it can result in social exclusion. Now, this quotation is from this textbook, Law at Work. Right, so if you can lay a hold on in this textbook, Law at Work, I'll give you the what you call the full citation if you can stick around with me. Now, a contract between an employer and an employee is an unequal one. If the relationship was to be left between the employer and the employee to be regulated by ordinary rules of contract, it is potentially abusive and prejudicial to the employee. It seeks to advantage the employer most of the time, because you remember the employer has a more powerful bargaining position than the employee. So the contract can be lawful but unfair, because you find that an employer may follow the correct procedure to dismiss an employee even for ulterior motives, for bad reasons. So the law then has to protect the vulnerable, or those in a relatively economically weaker position, that is the employees. Now we find that labor law ensures fair contractual relationships by permitting public law interference with labor relations. So in the ordinary, in terms of the law of contract, there should be minimal state interference, particularly in terms of the common law. But you find that the modern state engages a lot with the capital, with the employers, industrial operators, so as to ensure the protection of the vulnerable members of the community, who only have to sell their labor in exchange for money, which most of the time the remuneration is quite paltry and quite unrewarding and insignificant, to say the least. So we then come to the question to say, who are the parties to the labor law relationship? Who are the parties to the labor law contract? You find basically there are two persons who are involved, namely the employer and the employee. And this is what we call the individual labor law. Other parties include trade unions, employers, organizations, the state exercising its duty to protect individuals from the exploitative economic relationships. So these are the parties. Some relationships are contractual. For instance, the employer versus the employee relationship is based on contract. But other relationships are based on public law principles. For instance, the involvement of the state with the employers' organizations, or the state versus trade union relationship. The state comes in the exercise of its public power, enforcing, or rather exercising its duty to protect the people, the citizens, the private individuals from those holders of capital, who tend to be economically powerful by virtue of that. So we said we have individual labor law, and then we have collective labor law, where we are talking about collective bargaining relationships between employers and trade unions. Why are we saying that the employer-employee contract is individual? It's because it's one individual against one individual. One individual employee against one individual employer. But when it comes to collective bargaining, then we have trade unions, which means we have employees coming together to form a union, and then negotiating maybe with one employer, or negotiating within the sector. For instance, those in the health sector, or those in the mining sector, or those in the metalworking industry. So that then becomes a collective labor relationship. Now you find that the Labor Relations Act and the Basic Conditions of Employment Act specifically exclude independent contractors from the ambit of their protection, thus implying that their provisions only apply to employment relations. Now this is going to become very relevant when we look at the distinction between an employee and an independent contractor, because you see the labor law only concerns itself with the employees and not with independent contractors. It's also very important to remember that the Conciliation for Commission, Mediation and Arbitration, that's the CCMA, does not exercise jurisdiction on the disputes which are not based on employment relationships. For instance, in the Uber South Africa Technology Services Private Limited case versus National Union of Public Service and Allied Workers and others, in 2018, it became clear that the CCMA commissioner, who had purported to exercise jurisdiction on Uber, that is Uber South Africa, was found to have misdirected herself, because the finding then was that Uber South Africa, the relationship between Uber South Africa and the drivers of vehicles who provide Uber e-hailing services in South Africa were actually not, those people were not employees of Uber South Africa, as it were. You can find that case and read it. It makes very interesting reading when he talks about the distinction between what we know traditionally as these employee-employer relationships, and what we then find particularly with people that work in the gig economy, the e-hailing services, and all these e-lancers and those that are involved in that kind of work. This then brings us to the question of what an employment contract entails. What is it? Now, simply defined, in common law, it is a voluntary agreement between two parties, in terms of which one party, called an employee, places his or her labor potential at the disposal and under the control of the other party, called an employer, in exchange for some form of remuneration. Now we will look at the different types of remuneration as we proceed. Suffice it to note that the essentialia, or the essential elements of a contract of employment, are that it must be voluntary, so it must not be forced, otherwise it then becomes a kind of slavery. And there are two parties there that are involved. We said there's an employer and an employee, and then there is the issue of labor being provided by the employee to the employer, that is to another. And the last element that is essential there is remuneration. So those are the essential elements of a contract of employment. Now, for a distinction between essentialia, naturalia, and incidentalia of a contract, check out my video on the terms of a contract. I have done some work there on what we mean by the essential elements, the natural elements, as well as the incidental elements of a contract. So I will not spend much time here. Go look for that one. It's your duty to do so. I've already done my part. Now, come to section 213 of the Labor Relations Act. We will look deeply at the Labor Relations Act. Actually, there is a video dedicated to the Labor Relations Act, chapter 66 of 1995. There's also a consideration of section 1 of the Basic Conditions of Employment Act that's 57 of 1997. Now, how is an employment contract defined? They say an employee is any person, excluding an independent contractor, who works for another person for the state, and who receives or is entitled to receive any remuneration, and any other person who in any manner assists in carrying on or conducting the business of an employer. And employed and employment have the meanings corresponding to that of an employee. So it's very, very important to just check out what section 213 of the Labor Relations Act says, as well as section 1 of the Basic Conditions of Employment Act. They actually address the issue of what a contract of employment is. So if you noticed there was a reference to an independent contractor. The definition of an employee, according to section 213 of the Labor Relations Act, actually excluded an independent contractor. It said any person other than an independent contractor. So now it brings us to the issue of how do we then distinguish and identify, distinguish between the employee and independent contractor, so that we know who is an employee. Remember, we have also indicated that this independent contractor does not have recourse to the CCMA. an independent contractor cannot take his or her matter to the CCMA, because the CCMA is only meant to to bring conciliation and mediation, as well as arbitration, only to employers and employees. So to find out who's an employee, there are 4 tests that have been developed. We have the control test, the organizational test, the multiple or dominant impression test, and the economic dependence test. And then you find that Section 200A of the Labor Relations Act 66 of 1995 also has added some statutory presumption of who an employer is and what employment is. But now, taking into account maybe just the control test, it is often said that a person is an employee if that person is subordinated to the employer who exercises the right of control over the employee. That brings us into the concept of the unequal relationship that we spoke about, whereby the employee works for one employer at his or her premises for fixed hours. So the employer reserves the right to instruct the employee and to demand that the employee must attend to certain issues at specific times defined by the employer. So that's control. That, in other words, the employee doesn't have control over her life or her time, but her life and time is actually controlled by the employer, who then determines and defines what times and when and under what circumstances the labor or the work must be delivered. Then there's another test which is not such a favorable one. It's not such a popular test, and academics actually argue that this one doesn't add much value. It's very difficult to prove and sustain, but it simply says a person is an employee if, as a worker, the person is part and parcel of the organization of the employee, or rather of the employer. So are you a part of the organization of the employer? Then if so, then you are an employee of that organization. Then there is the issue of the multiple or the dominant test, or the dominant impression test. Now, courts have tended to defer a lot to this one, where they are saying if the relationship as a whole viewed gives an impression that you see, the employer has a right to choose who goes to work. The employer, or rather the one who consumes the labor, has the power to discipline, the power to dismiss the other. Then the one who has the power to choose who does the work, to discipline the other as well, to dismiss, is an employer, and there's an employment relationship there. If the employee's obligation to work for a given time or certain hours is controlled and determined by one who would be in the position of an employer, then there's an employment relationship, because you find that the employer provides the tools for the work, provides equipment for the work, which could be computers or whatever. If it's a journalist, the employer provides the cameras, video cameras, audio, what you call, all kinds of equipment that's going to be used. And then office space also gets to be provided by the employer. If there is such a provision of office space, then the relationship is one of employment. And then we find that the employer has a right to utilize the employee's labor potential as he or she sees fit. In other words, for instance, take the example of an employee who gets instructed by the employer. If you are a teacher, and then you get to the school or to the campus where you are supposed to work, and on that day they tell you that you're not going to teach in the classroom, but you're going to go and supervise maybe sporting activities. You can't then turn around, and if you're an employee, you can't say, oh no, well, I'm a teacher in the classroom for a specific subject like law or mathematics, so I'm not going to go out and participate in sporting activities. An employee doesn't have such liberty to choose what activities he or she is going to undertake. She is just instructed by the employer and must follow the instructions. Now, there is a test that they call the economic dependence test, which looks at whether the employee depends solely on the employer for economic survival. If that is the case, then it has been inferred that there is an employment relationship under such circumstances. And then there's also the issue of Section 200A of the Labor Relations Act, effected in terms of the amendment of 2002, which creates some statutory presumptions. Let's look at those statutory presumptions. There are quite a number of them, in fact 7 to be precise. So you find that the test to distinguish between an employee and an independent contractor in terms of the statutory presumptions of employment under Section 200A of the Labor Relations Act are such that the 7 points are as follows. Of course, the onus rests on the employer to show that there is no employment. In other words, if these 7 facts exist, then there is a presumption that an employment relationship has been established, and it is up to now the employer, the presumed employer, to dispel that kind of a presumption, to rebut that kind of a presumption. So the onus, the burden rests on the employer to prove that there is no employment. So what are the 7 criteria? The control of one person's work by another. If your work is controlled by another, then you are an employee. And if the hours of work subject you to another, you for certain hours of work you are subject to another person, then you are their employee. And if the person forms part and parcel of an organization, we spoke about that one above, yes, then you are an employee. If the person has worked for that other person, for instance, if you have given your labor to that other person for an average of 40 hours per month over the last 3 months, then you are an employee. Or if one person is economically dependent on the other, to whom he renders service, then the one who renders service is an employee. And if the tools and the equipment for doing the work are provided by the dominant party in this case, then the one who pays remuneration, then the one who's being paid is actually an employee. If the person, the presumed employee, works only for one person who's the presumed employer, then we have an employment relationship there. Take note of the fact that persons who meet the above criteria are eligible for CCMA protection, but those who do not meet the criteria are excluded. We have an example here of insurance agents. We've got an example of maybe building contractors. What about those people who provide training services from gig to gig, or those who are freelance writers and ghost writers who spend their time maybe writing for whatever assignment, and then at the end they are paid for the writing that they have done, and that's the end of the project. They are not called again afterwards except for another project. That person is not an employee, but he's just running from one gig to another. Talk about motivational speakers who go from one place to another. Each new assignment is a gig on its own, and so there is no permanent employment relationship that one would talk about. Now, Having spoken about these different factors in respect of the contract of employment, remember that it was discussed just to contextualize matters and to illustrate and show to whom this labor law applies. Maybe just take note of the fact that there are quite a number of sources of South African law. So in order to find what the law says, you must consult the Constitution, you must consult legislation, you must consult the common law, and you must refer to judicial precedent, that is the previous decisions of the courts, and you must refer to collective agreements, bargaining agreements of the past, and also refer to custom and usages. Now we are going to elaborate on that in a moment, but take note that these are the sources of South African labor law. So now let's go on and look at the Constitution. The Constitution of South Africa, we are talking here about the Constitution of South Africa of 1996. That's the final constitution, which initially was passed as Act 108 of 1996, but in terms of official citation, we have since dropped the 108 there. So it's just the Constitution of the Republic of South Africa of 1996. Now, in the interim constitution, that is the Act 200 of 1993 Constitution, which ushered in the first post-apartheid government. It was Section 27. Well, 26 also had said something on the rights, economic rights of individuals. But Section 27 was the one dedicated specifically to the issue of labor relations. But in terms of the current constitution, that's the one of 1996, Section 23, which is titled Labor Relations, reads as follows. Section 1 says everyone has a right to fair labor practices. So the issue of fair labor practices is very essential here, because in the past there were labor practices which seemed legal and lawful, but which tended to depart significantly and fundamentally from what could be deemed to be fair labor practices. So Section 23 enshrines that right to fair labor practices. It says every worker has the right to form and join a trade union, to participate in the activities and programs of a trade union, and to go on strike. And every employer, so there is the rights of the employees and the rights of the employer. So every employer has the right to form and join an employer's organization and to participate in the activities and programs of an employer's organization. And every trade union and every employer's organization has the right to determine its own administration, programs and activities, and to organize and to form and to join a federation. And every trade union, employers organization, and employer has the right to engage in collective bargaining. So there's provision for collective bargaining. We spoke earlier on about the distinction between individual labor law and collective labor law. So the issue of collective bargaining is, referenced there in subsection 5 of section 23. It says national legislation may be enacted to regulate collective bargaining to the extent that the legislation spells out the right in this chapter. The limitation must, or rather, to the extent that the legislation seeks to limit the right in this chapter, the limitation must comply with section 36(1). Section 36 is the limitation clause. And so we are saying national legislation may recognize union security arrangements contained in the collective agreements. And, taking into account that the legislation may limit a right in this chapter only in terms of section 36 You can refer to your section 36 of the Constitution, which talks about limitation of rights in terms of the law for general application. And there is a lot of jurisprudence, court decisions, explaining what must be observed in terms whenever the rights are being limited. So you may refer to that one. Then there is the issue of labor legislation. Quite a number of acts of parliament or legislation are relevant in this case. We have your Labor Relations Act 66 of 1995, which repealed and replaced the Labor Relations Act of 1966. Then you've got your Basic Conditions of Employment Act 75 of 1997. As I said, there are videos dedicated to each one of these. So look out for those, particularly the Labor Relations Act and the Basic Conditions of Employment Act. Then you've got your Employment Equity Act as well of 1998, and your Skills Development Act of 1998 as well, and then your Unemployment Insurance Law, that is the Act of 2001. Then you've got your Occupational Health and Safety Act, which also comes in to regulate this, matters of safety at the workplace. And then you've got your, COIDA, or your Compensation for Occupational Injuries and Disease Act 130 of 1993. So a practitioner of labor law really must have these handy and consult them frequently. How about your National Minimum Wage Act 9 of 2018? You must familiarize yourself with all these acts. Get them, they are available. And you find that most of this legislation is intended to introduce and maintain fairness into the contract between the employer and the employee through the protection of clearly defined rights, enabling collective bargaining, protection against unfair dismissal, protection against unfair labor practices, as well as protection against unfair discrimination. So this is the legislation. The list is not exhaustive, and as I have said, more work needs to be done, and I have already done some of it myself. So look out for those videos. Then there is the issue of the common law. We say that the common law is a very important source of labor law. You find that South Africa's labor law has its origins in Roman Dutch law, particularly in Roman law, where they had this issue of locatio conductio operarum, that is the contract of letting or hiring of personal services for remuneration. And that brings us back to the definition we discussed above, where we said in terms of the common law, a contract of employment is voluntary. It's a voluntary agreement between two parties, in terms of which one party, called an employee, places his or her labor potentially at the disposal of and under the control of the other, called an employer, in exchange for some remuneration. So that's what the common law says. It says no formalities are required to conclude that contract. It may be concluded orally or in writing, and the agreement may be express or tacit, sometimes by just way of giving instructions to one person, and then they take the instructions and they begin to do the work, and you pay them at the end of whatever period. Then a tacit agreement has come into place. It has not been expressly stated, but it's been tacitly concluded. Of course, you notice that in terms of Section 29.1 of the Basic Conditions of Employment Act, there are some variations now to the common law. It is arguable, among others, that the Basic Conditions of Employment Act has not shifted has not changed or altered the common law, but it simply introduces a new element where he says the employer must furnish the employee with written particulars of employment. So in a way, one would argue that it introduces writing as a requirement. And then you find that the common law defines the duties of an employer and those of an employee. Let's look at some of the manner in which those rights are defined, the rights and the duties. With regards to the duties of an employer, the common law says that it is the duty of the employer to remunerate the employee at the agreed time. You know, premising everything on the no work, no pay rule. It says that, you see, there is no rule. In fact, the employer is not obliged to pay an employee who has not worked. So there is a rule against unjustified enrichment of both the employer and the employee. The employer cannot use the services of an employee and not pay for them. In the same way, an employee cannot expect to be paid when he or she has not worked. So remuneration must be paid either in cash or otherwise as agreed. So there could be other payments, other forms of payment such as accommodation or payment in goods. That's also permissible if the two parties have agreed to that. A remuneration need not be fixed, but it must be ascertainable. In other words, it could be maybe fixed at hourly rates or daily rates or whatever. Yeah, but it must not be based on the completion of a task. It must only be based on, in either time. Yeah, it must be based on time, like 1 hour, 1 day, 1 week, whatever it might be called. And then we've got our National Minimum Wage Act 9 of 2018, as well as the payment thresholds that in terms of the Basic Conditions of Employment Act, your sections 9 to 18 a requirement. So all those are factors to be considered with respect to remuneration. And the duties of an employer include the right, in fact, the duty to receive the employee into service. In other words, the employer must open the gates for the employee to come in and work. If the employer doesn't open up the gates, she's still obliged to pay the employee, even if the employee has not worked. So imagine an employee who comes to the workplace and is never assigned any work and spends the whole day browsing their internet on their phone, scrolling their phone, and so on. If the employer has not bothered to assign the employee any work, then the employer must still pay at the end of the accounting period, whether it's a week or it's a month, whatever they've agreed upon. So the employer has no duty to provide work except in exceptional scenarios. There are scenarios where work must be provided. Take an example of an apprentice or somebody who is an intern. That one must be provided with work so that they can learn. Because remember, that person is on a learning contract and they can't learn anything if they are not given the work to practice the skill, that to develop the skill that they need to in terms of that contract of internship. So it could be a candidate attorney who comes in. He must be sent out to the courts, maybe to apply for bail, to have a feel of what it means to be a candidate or a lawyer, to draft whatever summons, to draft whatever communication needs to be drafted, so that he or she has practical work as assigned by the employer. So in the case where the employer doesn't provide any work, then that would be a serious breach of contract. What about somebody who's in a contract, maybe as an actor or as an actress? That person must actually be assigned work to act, otherwise their career will sink into oblivion. Because remember, if you are no longer being seen or watched on television as an actor or actress, then people forget about you, so your career dies. In that case, then the employer has a duty to provide the work. And how about, you see, the employer has a duty to also provide safe working conditions in terms of the Occupational Health and Safety Act. And to act fairly to the employee, you must act fairly, assign work that is feasible, work that is realizable and attainable within the context of the available time. The employer must, comply with statutory duties, and the employer may be held vicariously liable, that is, for the acts or omissions of the employee committed or omitted during the course and the scope of the duties. So then there are certain conditions that must be met in order for the employer to be held vicariously liable. So there must be a valid, what you call, contract of employment between the two, and then the act or the conduct of the employee must have been committed in carrying out the course of duty within the scope of the work that is assigned. So for instance, imagine an employee who is employed as a security officer by an employer. If during the carrying out of the duties of a security officer, he causes injury, maybe to a passerby, maybe by discharging a firearm, then the employer may be held vicariously liable and responsible for that. But what about a security officer who then departs from his station or from her station, takes a drive into town in a private vehicle of his own and causes an accident there, even if it occurred during the working hours? If the accident that caused injury maybe to a third party was not, if it did not happen within the course and the scope of the duties assigned by the employer, then the third party has no recourse to the employee. He cannot claim, or he cannot stand on vicarious liability to hold the employer liable for the conduct of the employee. So it must be in the course and the scope of the duties of the employer. That's very, very important to take note of. So there are also some common law duties of the employee. The employee must satisfy those common law duties as well. What are those common law duties? The employee has a duty to place his or her labor at the potential disposal of the employer. So on the basis of no work, no pay rule, which applies here, the employee will not demand or require any remuneration if he or she has not worked. So she must place her labor at potential disposal. In other words, she must be available to be sent and to be assigned work to do. So in other words, if he or she sits at home, then she is not providing any potential labor to be used by the employer. So that is a violation of the duties of the employer, of the employee. And the employee has a duty to work competently without negligence, with the duty, with the care, with diligence, giving it the maximum capacity, rather the excellence that he or she commands in respect of that work. The employee has a duty to obey all reasonable and lawful commands and instructions of the employer, and to act in good faith. In other words, the employee has a duty not to divulge the employer's confidential information to third parties, and must work diligently to promote the business of the employer and not to compete with the employer. That is, so we are looking at restraint of trade. If, for instance, one is employed as a mechanic, a motor mechanic, an automotive a technician or mechanic, and then while clients come into the workshop of the employer, that mechanic then begins to take their contact addresses and redirects them to bring their vehicles to his backyard after working hours, so that he can fix those cars by his backyard instead of fixing them at the workplace. Then that kind of an employee is actually competing against the employer. That's unethical, and it is actually a breach of the duties of an employee. So we must not compete with the employer and must act honestly. So there is a requirement that the employee must act with honesty. That is those are the elements of good faith, or the Uberima fides principle. No mala fides in this case, but bona fides is what we require. Well, so talking up, we remember we began to talk about the sources of South African labor law. We said there was the constitution. We said then there was the first it was the constitution, then the legislation, where we identified quite a number of pieces of legislation, including your Labor Relations Act 66 of 1995, your Basic Conditions of Employment Act, your Skills Development Act, your Employment Equity Act, your Occupational Health and Safety Act, your occupational, what you call it? We spoke also about National Minimum Wage Act, which we said were some of the acts that were important in determining what South African labor law says about in answering specific questions. And then we spoke about the common law, where we elaborated on the nature of an employment contract in terms of labor law, in terms of the common law. And then we spoke about the duties of an employer, the duties of an employee. Now we've come to talk about the issue of judicial precedent, where we are saying, in finding out what the law says, you may consult previously decided cases which are applicable in South African law on the basis of the stare decisis principle, which says that decisions of superior courts are binding on lower courts and the courts of comparative jurisdictional status. And then there's also the issue of collective bargaining agreements or bargaining council awards. All these, as resolutions and collective agreements, they serve as authoritative sources of law for future disputes based on similar facts, that is, comparably similar facts. And then we've got also the issue of custom and usages, methods previously and consistently employed to resolve disputes can be used to resolve similar problems in future. So you must revisit those and take into account that trade usages are very, very important in that respect. Now, we have come to the end of this particular video, not the video series. Take note of that. As I have highlighted to you, there are many other videos that cover some of the aspects of South African labor law. Suffice to say that this lecture discussed the meaning of labor law. It identified labor law relationships. It identified sources of South African labor law and explored the common law nature of contract of employment. And then there are other lectures which within the series which trace For instance, we have one that traces the historical developments of South African labor law, from the pre-colonial through the colonial through apartheid, right up to 1993. How were labor relations handled? Of course, you know that there was exclusion of the blacks and so on and so forth. So you can check our videos that talk about the Wareham Commission and its impact, and the emergence of unions, that there's black unions, and what impact they had, not only on the labor front but even on the political front. So we have videos that discuss the beginning and the end of the employment contract, that is creation and termination of a contract of employment, the conditions necessary for fair dismissal of employees, and the rights, duties, and responsibilities of employers and employees in the employment relationship, the conditions of work during the life of the relationship, that is the employer-employee relationship, the right to strike, lockout, collective action, collective bargaining, the types of strikes. We're talking here about the protected and the unprotected strikes, the secondary strikes, your collective bargaining and dispute resolution mechanisms, and your dispute resolution. This time we are looking at the CCMA and the labor courts. Now, so much about that. So look out for the videos that I've actually spoken about. Otherwise, thank you for your time. Remember once more to subscribe to the channel, to like the video, to share the videos with your friends, to share the channel with your friends. Thank you very much. Enjoy the rest of your day.